5 seconds. The state of Haryana and its officers has filed the instant appeal under clause 10 of the letters patent against the judgment dated 27/1/2010 rendered by the learned single judge, allowing the writ petition filed by the petitioner respondent by quashing orders of reconstruction of adverse annual confidential reports as well as compulsory retirement passed against him. He has further been held entitled to all consequential benefits. The learned single judge has found that the controversy involved in the writ petition is covered by a judgment rendered in the case of Amarjit Kaur versus State of Punjab and others, and a division bench judgment of this court rendered in the case of Ram Nivas. It has been held that there is no provision under the Punjab Police Rules 1934 as applicable to Haryana or in any instructions or subordinate legislation providing for review of an order passed by the predecessor in office, and that the power of review cannot be exercised unless it is expressly provided by the statute. The undisputed facts of the present case are that a complaint was made against the petitioner respondent by one ASI Basant Pal when he was posted as a head constable in the police post Gurgaon. In a regular departmental enquiry, he was found guilty and punishment of reversion from the post of head constable to that of constable was ordered to be inflicted upon him. He made a representation before the Inspector General of Police, Gurgaon Range, Gurgaon, who converted the punishment of reversion into stoppage of one increment wide order dated 28/4/2001. In the meanwhile, some adverse remarks in the ACR of the petitioner respondent were recorded by the Senior Superintendent of Police, Gurgaon, for the period from 1/4/1999 to 11/10/1999. It has come on record that the petitioner respondent made different representations from time to time for expunging the adverse remarks. It is pertinent to mention that against the judgment of stoppage of one increment as well as adverse remarks, the petitioner respondent filed a civil suit which was partly decreed by the Civil Judge, Junior Division, Gurgaon, wide judgment and order / decree dated 27/9/2004. The order dated 28/4/2001 stopping his one increment was set aside and the appellants were directed to release one increment. However, his prayer for expunging adverse remarks was not accepted by the civil court. Even the appeal filed by the appellants was dismissed by the learned district judge, Gurgaon. Despite the judicial verdict declining the expunging adverse remarks, the petitioner respondent again filed a consolidated representation dated 7/1/2005 for expunction of all the adverse remarks, claiming that the order of stoppage of one increment has been set aside by the civil court. The Inspector General of Police, Gurgaon Range, wide order dated 28/1/2005 accepted the representation and directed expunging of his adverse remarks for the period 1/4/1999 to 11/10/1999. On 5/9/2006, the Director General of Police, Haryana, issued a show cause notice to the petitioner respondent stating that he was given undue benefit by expunging his adverse remarks for the aforesaid period, and the orders dated 27/2002 and 28/1/2005 passed by the Inspector General of Police, Gurgaon Range, Gurgaon, were liable to be recalled and he is to be compulsorily retired. Then the petitioner filed reply to the show cause notice. Thereafter, he also filed CWP number 16514 of 2006 challenging the show cause notice. However, the said writ petition was dismissed as withdrawn, giving liberty to the petitioner to file a fresh one. On 30/10/2006, the Director General of Police, Haryana, passed an order for restoration and reconstruction of the adverse remarks in the ACR of the petitioner respondent. Feeling aggrieved, the petitioner respondent number 1 filed CWP number 9128 of 2006.